The Socio-Economic Rights Institute has welcomed the Western Cape High Court order for the provision of alternative accommodation to more than 100 people soon to be evicted from public spaces in Cape Town's inner city. SERI is representing the group, and the court says that the group should be provided with alternative accommodation in one of the city's shelters. Let's explore this further now and speak to Nkosinathi Sithole, Socio-Economic Rights Institute of South Africa's senior attorney. Thank you so much for your time, Mr. Sithole. When you look at this particular matter, at some point, SERI, of course, from the beginning conceding that the occupation of sites around the inner city was unlawful, but still defending the group and saying that, there must be alternative accommodation that is provided for here. Why was it important for the organization to get involved in this particular matter?
Good evening, Bongiwe, and good evening to your viewers as well. So you will remember that with the advent of our democracy, unlawful occupation of land was decriminalized.
Yeah.
So unlike in the apartheid days where you'll be found on land and be called a squatter and be summarily evicted and arrested on top of that, that was abolished. Because that was simply inhumane, and those were laws made to protect only a few. Now, we know that the scars of apartheid still exist, and they are still deep in millions of South Africans. When you look at the laws such as your Group Areas Act, forced removals, and so on. This cycle has led to people being in unlawful occupation of land, people living on the street like these people do. And therefore, it is important for human rights organizations like us to step in and defend those people's rights when we are called to do so.
And speaking about, this particular matter, there was something that sparked my interest. I mean, the second concession, for example, the city agreeing to amend the shelter rules to make them more humane and compliant with the Constitution. How inhumane would you say they were?
No, they're very inhumane. I'll give you examples of them. First, when you are being relocated into this shelter, you can only stay there for 3 to 6 months, and thereafter you are forced out. Now, this defeats all logic. Where are you supposed to go afterwards if you have been taken from the street and now you are told that your 6 months is up? Secondly, when you are there, during the course of these 6 months, you are forced to leave the shelter every day from 8 and only return around 6. Should you come after a certain time, say I think 8, then you are locked out. You are not. You will not be permitted to come and sleep in the shelter. What happens when you are sick? What happens when you are an elderly person? What happens when you are a woman and it's that time of the month? You'll be forced to go and sleep in the park and in the cold, because whether it's raining or not, you are forced to leave. Now, if you are living with your partner, there you'll be separated because you're not permitted to live with your partner. There are no family units.
Yeah.
So those rules are inhumane, and in fact they've been declared unconstitutional before by the Constitutional Court.
Briefly then, do you have any idea what these amendments now look like?
So now I beg your pardon,
there's this concession on the amendment of these particular shelter rules, and some of which you've just mentioned. Do you have any idea what they are now going to be looking like?
Yes. So firstly now, after the 6 months, they will not be taken out of the shelter. They will stay there up until they are able to find alternative accommodation for themselves. the lockout rule will not apply to our clients. The family segregation rule will not apply to them. In fact, those that have partners will then be permitted to occupy a family unit section. So all of those rules with regards to our clients have been relaxed.
And the mayor posting on social media a video, of course, following this particular order, saying that, and I'm sure you've seen it, that, it was always the last resort, the city's last resort when it comes to evictions, and saying that it extends, of course, the interventions, that it's temporary accommodation known as safe spaces, knowing that some would not take this particular intervention, but others will. And, where they were not taken up, they will then have to rely on the courts to then be able to help them, saying that for them this particular order is now good news. How do you respond?
Well, if that's the city's attitude, then that is fine. But they know very well that, first of all, when they commenced this eviction, there was no offer at all for alternative accommodation. It was only because this eviction had been defended, and through the courts, they were forced to then concede that the law requires that they provide alternative accommodation.
Is there, pardon me for coming in there, is there a way though that these matters can be prevented before they get to the courts? Because, and I ask this because, in some of the cases, you look at some of the situation, for example, there wouldn't be enough budget, or sometimes it's not sustainable in some of these particular cities to be able to give alternative accommodation to people. So is there a more proactive approach that maybe yourselves, the cities, and maybe other organizations can take and sit at the table in order to be able to address this particular crisis of homelessness?
Definitely. In fact, our law allows for that, and that is meaningful engagement. Our law says that before considering an eviction, parties must first sit down and meaningfully engage to find ways in order to prevent to have to get into litigation. So had the city done that, consulted properly with people, invited all stakeholders, the whole thing could have been prevented. Because people would have maybe gone to those shelters amicably without being forced, or the city could have been in a position to provide a better solution at a time convenient to it. But it simply didn't do that. In fact, it was forced by this court to do that in the middle of litigation, something which could have been done earlier.
It does look like this is a broader conversation, I suppose, that, we even need to have, looking at the country, for example, and some of the challenges that we're seeing in some of the provinces. But thank you so much for your time, Nkosinathi. And we are, of course, hoping to hear even from the city of Cape Town in order to also be giving them their perspective on this particular ruling. But do appreciate your insights. Nkosinathi Sithole, Socio-Economic Rights Institute of South Africa's senior attorney.